No mention. Just joking.
Item number 1 for pronouncement of judgment.
Nobody is there on behalf of the state. I'll read out only the operative portion. Accordingly, on this court being made aware of such error, we find that the review petitioners have been able to make out a case for reconsideration of the judgment dated so and so. This petition is accordingly allowed. The judgment dated 13/6/2024 passed in WA number 18 of 2024 is hereby set aside. The appeal is restored and to be heard on merits. Parties are directed to be heard in the matter on the next date fixed. This is the appeal on 1/5/2025 for hearing. Petition disposed of.
Highly obliged.
Excuse me. We can modify that. Single bench will sit after this.
My please Lordship, my Lord, I need some accommodation. Hearing number 5 to 11, my Lord. Recently, the petitioner has filed a regards to writ petition. So we got the instruction to file a shorter counter affidavit.
Who's for the petitioner?
Mr. Sheikh, my friend, I saw him just here.
He's here.
He's around here. So I pray for a week's time. What happened, my Lord? The pleading completed, matter proceeded for hearing, and when the matter was about to finish, they sought for amendment of the main writ petition itself, and Lordship allowed it, and they filed a regarded petition recently, and we received the copy. We also received instruction from the party, so we want to give a short counter to that. A week time. 5 to 11. My friend is there for the petitioner.
You're appearing for?
Appearing for private school managing committee and the principal.
I'm for the private party.
He is for the number 6.
Yes, Mr. Debnat, what is your...
So I have to file, it is going to be ready.
File what?
Sometimes it's required.
What are you supposed to file?
To reply to this amendment petition.
Mr. H.L. Sir Rasul Arad, Senior Counsel, appearing for the respondent numbers
4 and 5.
4 and 5. Oblique Managing Committee has sought for some more time to file the reply, response to the amended petition. Amended petition. Similarly, Mr. R. Debnat, Counsel, appearing for respondent number
6,
has also sought for some time to file similar response. On Premier, this is matter after 2 weeks.
in another cases I will be in 8. Some respondent number will change in other cases.
Okay, we'll check them.
Deeply
May I please, Your Lordship? I beg to mention item number 14, Your Lordship. I have already informed the other respondent, Your Lordship. We have just received the affidavit filed by the state day before yesterday, so we need some time to take instruction, Your Lordship.
Additional affidavit was filed.
Where you say that the petitioner has participated in the selection process.
Yes, Mr. KP is the counsel with the brief. He has already filed, I am instructed to say.
On Premier petitioner, this is matter after 2 weeks.
2 weeks.
Much obliged, Your Lordship.
Daily list item number 1.
Please, Lordship, this appeal on the last occasion, my Lord, was kind enough to condone the delay of 5 days. 2 days for hearing, for admission, my Lord. Fairly simple matter, my Lord. The primary ground that we've taken in this appeal, the primary ground is a very straightforward and simple ground, my Lord. In this matter, respondent number 2, that is the driver cum owner of our insured vehicle, he was holding a learner's license. At the time of accident, there was no accompanying person who was holding a proper license, my Lord. And the rule is very clear, the law is very clear, that a learner's license, a person holding a learner's license has to be accompanied at all times when driving by a person holding a proper, valid, effective license, my Lord. That was not the case. So this is a situation where there's been a violation of the policy, my Lord, of the driving license clause. Now, in this matter, my Lord, the MACT has, number one, appreciated that there's been a violation of the policy. But number two, the liability has been imposed on us, that we are to satisfy the judgment, pay the compensation. Number 3, the liberty to pay and recover has been given to us. But our point, my lord, through this appeal, is, my lord, that the liberty to pay and recover would only be in a situation where there has been an inadvertent violation of the policy. In other words, for example, my lord, if the owner engages the driver has a license which looks valid. Subsequently, it turns out that it was an invalid license, then the liberty to pay and recover comes in, my lord. But in a situation where there has been a willful violation, that in that situation, the law of this laid down by the Supreme Court is also very clear on this point. If there has been a willful violation, then insurance company is completely exonerated. It is released from liability. That is our case through this appeal, my lord. Because of the fact that the respondent number 2 knew that he was carrying a learner's license, knew that he is supposed to be accompanied by somebody. Not being accompanied by somebody holding a valid license means he had willfully violated the policy, my lord.
What is the type of vehicle in question?
Our insured vehicle, my lord, is a scooty, is a motorcycle. Is a motorcycle, and the deceased person, my lord, was riding a scooty. So there were 2 vehicles involved. Ours is a motorcycle, my lord.
No issue of contributory negligence.
That didn't arise, but the issue of negligence is also there. I'll take my lord through it subsequently. But the primary ground is this: that we, as per the law laid down by Supreme Court, we have zero liability in this matter.
Have you implemented the owner and driver?
Yes, my lord. Number 2.
The owner and driver.
Yes, my lord. And as far as number 2 is concerned, my lord, the notice had been served. Affidavit of service had been also filed. If lordship kindly looks at 25th February order, my lord, passed in the miss case, the condonation case, my lord. Miss case 1. 25th February 2025. Miss case 1, my lord. In this order, my lord, lordship will see that notice had been served. Affidavit of service was filed on 19th February. Lordship was pleased to wait for appearance of the respondent number 2. But till date, there's been no appearance. I would request for an ex parte order against number 2, my lord.
No, when the condonation application was allowed, no ex parte order was passed against?
No, my lord. After 25th February, no specific order was passed, my lord.
How can it be? No, order has been passed.
Sorry, my lord, I'm not.
Order dated 2/4/2025 in. Is this appeal 1 of 2025?
I'm sorry, my lord, I missed out that paragraph, paragraph 3, my lord. Apologize, my lord. I thought this was only for condonation. Paragraph 3, lordship has declared ex parte.
But Mr. S. Jindal, counsel for the appellant. On consideration of the prayer made, this court is of the opinion that this court is convinced that the merits of the appeal is required to be heard. Accordingly, this appeal is admitted. Notice upon the respondent number 1 is not required to be served, as he is. You are respondent number 1. Number 1, man. He or she?
She.
She is duly represented by Mr. Mansuri, learned counsel. It is also to be mentioned that the respondent 2, owner of the driver of the vehicle in question, has failed to appear before this court on when the application for condonation of delay was taken up, wherein by order dated 2/4/25, this court has proceeded ex parte against such respondent. Accordingly, it stands to reason that the respondent number 2 is not interested in defending this case, defending his case in this matter. The matter shall proceed ex parte against him. Records of the case from the Leret member MSCT
Shillong.
is hereby called for. Any paperwork required?
Not required. Not required.
This is matter. This is matter up to 2 weeks.
2 weeks. Obliged.
Item number 2.
Lordship, the matter will start after 2 weeks because the position which recently one witness examined, I want to bring on records.
It will come again on 17/4, Your Lordship, before the learned special judge.
How many witnesses are here?
9, Your Lordship. Out of 9,
And,
5 already
5
examined
witness.
and cross-examined, Your Lordship.
5 witnesses examined.
Right.
But as on today, all the witness examined I have seen, none of the witness said anything against me.
That would be to
That
the
is on the
advantage of the bail applicant, Your Lordship.
I'll just want to bring the evidence of PW5 on records. That is what the independent witnesses.
Mr. Qureshi, it would have been better for you to pursue the bail application before the trial court, because the trial court is season of the
Matter.
court case. You see, it can go through its own proceedings.
Lordship, in this case, if the liberty is granted by this court to move before the learned
But
judge, special judge,
that's up to you.
no, liberty, at least some observation and liberty may be given so that I can move it.
Unnecessarily, you're just bordering this court. Do that.
Liberty may be given. Lordship.
Mr. IMF Qureshi, counsel for the petitioner, has submitted that he may be allowed to withdraw this case and with liberty to file a similar application before the trial court for your law. Yes. Mr. Andishwara AG has no objection to the prayer made. On consideration of the submission made, on the consideration of the prayer made, the same is allowed. Petition is hereby dismissed as withdrawn with liberty sought for allowed.
Yes.
Lordship, may I crave Your Lordship indulgence? Lordship, the disk report are not working. Lordship, it's very difficult. If Lordship kindly,
You are,
we find it very difficult, Your Lordship. Sometimes
you are telling me. I'm looking at her every day,
we.
asking her when you
This is my humble request, Your Lordship.
Okay.
Lordship.
So ông chịu to where they will said ne? Okay. I think I'm also
Lordship. Kindly, Your Lordship. Highly obliged, Your Lordship.
we'll take it up. Come on,
Item number 3.
May it please Your Lordship. Your Lordship, I'm appearing on behalf of the District Council, GHDC. Your Lordship, I pray that this matter may be listed after 2 weeks for filing of the affidavit.
What is required here?
They have to file their affidavit and reply, Your Lordship.
Instruction, my lord, with regard to the
Suspension.
Suspension, my lord. The JCDC has, by the impugn order, my lord, the petitioner was suspended, and the respondent number 6 is the caretaker of the placement as a government caretaker.
But why is this matter come before? Oh,
My lord.
Justice, thank you, has recused.
Yes, my
Your
lord.
Lordship.
You're a petitioner.
Your Lordship, I'm the petitioner.
Mr. Hassan, you have filed your counter?
No, my lord. This is the second time, my lord, we seek not yet received any instruction.
Mr. Learned Counsel, appearing on behalf of the respondent number 1 to 5, JCDC has sought for time to file the counter affidavit. Likewise, Mr. S.K. Hassan, Learned Counsel for the respondent number 6, has also sought indulgence of this court to file the counter within the next date fix. Miss Learned Counsel has appeared on behalf of the petitioner. On premate, it seems allowed. This matter up to 2 weeks.
2 weeks. 2 weeks.
Shall you oblige, Your Lordship?
Shall you oblige, Your Lordship?
Item number 4.
My lord, this matter, my lord, I'm praying if this matter can be taken up next week, my lord.
Yes, you might as well withdraw this matter.
My lord, this matter was heard, my lord, at length, my lord, by the petitioner side as well as from the respondent side. It is for us to reply to their submission.
That's exactly the point.
My lord.
I've heard you. I don't know what you have submitted.
My lord, I'm praying if this matter can be taken up next week.
2015 matter. Miss R. Dutta, Learned Counsel, appearing for the petitioner, has once again sought for accommodation on grounds of self-guilty. Parties are reminded that this court time and again has requested them to pursue with this matter diligently. Even then, time and again, accommodation is sought for, which was allowed by this court. Be that as it may, as a last chance, the prayer made by the petitioner is allowed. No further adjournment will henceforth be allowed. This is matter after 2 weeks. I'll give you 2 weeks and
Thank Your Lordship, we're ready with the matter. Thank Your Lordship, we are ready with the matter.
you are ready, but they are to pursue the matter. But you said you have heard, I mean your...
It's for ours, it's fixed for our submission, my lord. They have already replied to our, they have already replied, my lord.
I don't understand.
But the matter was heard, my lord, the petitioner was heard, then they have replied.
Oh, is that
My lord,
so?
it's our submission, my lord.
Okay. You were heard,
My lord,
they had replied.
my lord.
Now you
Now
have to-
we have to reply to their submission, my lord.
This is the problem when the matter is delayed.
My lord, there is another connected matter also, my lord. Tagged along with this matter, my lord.
2 weeks there.
Right, Your Lordship.
Item number 12.
May it please Your Lordship, the conducting counsel is on legs, Your Lordship. May kindly take this matter by the end of the board, Your Lordship.
Your Lordship, I am accepting notice on behalf of respondent number 5. Your Lordship, for DSGI.
Respondent number 5.
Respondent number 5, Your Lordship. for forest, environment and forest.
This is
12.
item number 12.
12.
I meant to say 13. Now 12 is being called.
12 is, oh, it's a mistake with the causeless.
I was wondering,
We are ready for the hearing.
how come the forest department is involved in a murder case?
My lord, similar is the situation for the respondent counsel.
Wait, please, Your Lordship. Your Lordship, Mr. Piobin, he's on legs. Before
What is required here?
we have already served a copy to the union, Your Lordship.
Lordship, I'm appearing for the union. For Dr. N. Mosika, Your Lordship.
So that's it. What is
Lordship, I
required is
can-
for them to, to
Lordship,
appear,
will
and they have
seek
appeared.
instructions.
Have you filed your amended petition?
Amended petition. No, Your Lordship, we haven't filed yet.
Oh, you see, Union of India has only been arrayed as respondent 5.
Yes, Your Lordship.
Must have been by the by a relevant order, which would entail action from your side as far as the petition is concerned. No, 5 is not there.
Your Lordship, I kindly pray for 2 weeks' time.
You are not aware of the case. Miss. You don't know what is going on. I'm asking you about the status of respondent 5, whether it's a newly implemented respondent or not.
Yes, Your Lordship, it has been already implemented as respondent number 5.
Exactly.
In the main.
When I asked you about the amended petition, you said yes, it has been filed. At least you should go through read the file and see what is required, what is not. So you have just entered appearance.
Yes,
today.
Your Lordship.
My lord, I'm for 124. Listing.
Have you filed your counter?
We have filed. They are supposed to enter appearance, so we just.
Of course, that's the different thing. Mr. Direct Counsel has submitted that she's entering appearance on behalf of the respondent 5 through the Leonard DSGI and has sought for time to file the counter affidavit in this case. On premier, this seems low. This is not 2 weeks.
Suitably obliged.
Item number 15.
My lord, in the last occasion, my submission has reached to the decree passed by the first trial court, and I submitted that, my lord, the trial court did not grant any relief to the respondent here, my lord, and that the operative portion of the very judgment and decree is available in page number 117. Page number 117 and 118, the last part of the judgment and decree. Yes, 117 to 118.
Yes.
Now, last time, my lord, I have pointed out that no relief was given to the defendant. The suit filed by the plaintiff appellant was dismissed. Now, aggrieved with this, they prefer first appeal. And the first memo of appeal, they have taken 4 grounds. And one of the grounds is that relief was granted to me by the trial court without filing a counter claim from my side. Now, memo of appeal is, my lord, page number 120. Yes. And I would come to the ground, page number 132.
132.
Yes. Now, ground number 4 in that 132, my lord may kindly see, for that the effect of the impugned judgment is to grant relief to the respondent without there even by being a counterclaim filed by the respondent. Now, that while passing the impugned order, the trial court below has totally ignored the evidence on record, which clearly shows that the list did such being relied on by the respondent clearly and manifestly pertain to the entity called the Shillong Sports Club and not the appellant club. On the other hand, the court below has overlooked the authenticity and validity of the list deed and such, which was clearly executed between the parties. Now, ground 4 say that relief was granted to me without counter. Now, when we see the judgment rendered by the trial court, there no such relief was ever granted to me. The suit filed by them was dismissed. Now, subsequently, they realized that the 4 grounds, major grounds they have taken, appears to be short of the comprehensive grounds. So, therefore, they file another miscase for adding the grounds. My lord may kindly come to page number 141. 141. They file a case number 1D of 2016, seeking additional grounds to be incorporated in the memo of appeal. And they have that was considered by the trial court and accepted. And I would point out one ground, with your lordship permission. Page number 144. Ground 5. See, ground 4 and 5 be same point, more or less. my Lord, with Lordship permission. For that, while passing the impugned judgment, the learned trial court below ignored a vital aspect of the matter, which was that there was no material that had been placed on record by the respondent defendant to justify its stand that it was the suit property that had been returned by the appellant to the defendant in 1920. In other words, even assuming but not conceding that 6 acres out of the total 16.91 acres had been returned by the appellant club to the defendant clan in 1923, there was no clarity that it was the suit property that was the 6 acres in question. If the respondent defendant was claiming this suit property as a said 6 acres, the respondent defendant had to substantiate this, which was not done. By ignoring this failure on the part of the respondent defendant, the learned trial court below has committed a patent and manifest error. For that, para 13 of the impugned judgment contains the observation of the learned court below that the appellant had apparently not objected earlier to the allotment of different patas relating to portions of the suit land to various persons. However, it is submitted with all due respect that this, even if true, cannot be a ground for dismissal of the suit of the appellant, as had already been submitted before the trial court below. It is not even clear where these portions of land that have been apparently been allotted are situated and whether they are within the suit property. Further, this alleged allotment, even if true, were made behind the back of the appellant club. Therefore, there is no question of appellant having objected to the same for the reason that the appellant was not aware of these alleged allotments. In any event, leaving aside the portions for which patas were allegedly allotted by the defendant, the appellant still had a good case for the unallotted portions. However, the effect of the impugned judgment has been that the rights of the appellant over the entire suit property has been thrown on the cloud, thereby disturbing a position that has been existed for almost a century. Now, if I gather here properly, they have taken the ground that they are not aware of the allotment given to 5, including Rangpashno. My Lord, and just in front of their plot, 5 structures came up long ago. So can it be correct to believe that they are not aware? In view of this position, my Lord, Mr. Singh, the plaintiff, deposed before the court, even admitted in cross that he was not aware whether Shillong Club has raised objection or not. He admitted that he did not raise any objection. In view of the trial court, applied the principle of section 115 of the Evidence Act. And second point, he raised that even assuming that, okay, allotment has been done. Now, allotment to these 5 entities, 5 individuals, it comes around the total 39,400 something square feet out of 6 acres. Remaining 5 acres remain. So they are saying that even if allotment given to these 4 persons assumed to be correct, or because of my negligence taken away, remaining part of the unallotted plot should be with me. That is exactly. So if that is the case, they have a 10.19 acres in their hand under the lease agreement, which I don't dispute. So if the unallotted plot of 6 acres also need to be with them, then they will get my Lord, 15 acres, more than 50 acres, beyond the listed. Therefore, the suit was structured in such a way that, my Lord, my paper, the listed I have, I entitled the size of this table only. But the real intention of filing the suit is that I intend to get this one also. So if I say that no, I entitled this one as under my paper, then when the real structure survey comes, my paper will say only confined to this. Therefore, they frame the suit in such a way that which portion is the disputed area. They just simply say the suit land. The suit land is, as per the listed, it is only 10 acres. And within that confine of 10 acres, there is no suit.
No, it was said that it is on the certain portion.
Certain portion. Now, it is the duty of the plaintiff to identify which certain portion. North, south, east, west, number 1. Number two, how many square feet or acres is under dispute in certain part of the listed area. They fail. So he himself in deposition and cross said that I am not aware of the original site of the location of the original listed. He himself is not aware. Which part of the area is a disputed area? And he knows that he cannot travel beyond the listed. But his intention is he's eyeing for the land that is situated beyond the listed. Therefore, my lord, the trial court, conscious of the fact that he fails to prove the case, and the principle of waiver estoppel comes into play, therefore suit was dismissed. No relief was ever granted. Now, even if trial court said, yes, your listed is illegal, you're the owner of the land under the listed, the real disputed area do not fall within the listed. He cannot get. Even till today, my lord, it is within their possession. We're not claiming. Thank you, claim is not claiming that 10.19 acres till today under the list. Therefore, the 6 acres, the disputed area, which according to us the southern part of the Shillong Club, is within the 6 acres beyond the listed. That was clearly spelled out in the notice given to them in 2013. That we want to take it back, the land beyond the listed. Beyond the listed. So this is the additional ground they have given. And subsequently, the missed case was accepted, allowed by the trial, by the appellate court. Lordship, can you see that order is in page number page number 148. 148.
Yes.
That was allowed. And finally, the matter proceeded for hearing of the main appeal.
So the new grounds were incorporated?
Yes, incorporated. So first appellate court allowed them to incorporate. So some additional ground they put apart from the earlier grounds mentioned in the memo of appeal. So matter went for final hearing, and the judgment was pronounced by the first appellate court. Started from page number 149. Now I would come to, my lord, page 173.
Yes.
Well, now started from my point, Bharat 86.
Yes.
Plaintiff Appellant Club relied on the registered deed listed dated such and such, and the same was marked as that paper mark 1. But during cross-examination, PW1 Sri Parambil Singh testified that he was not aware of the location of the original document, dated 20 March 2023, and he did not produce before the court today. It is, however, in their possession. So it's a reproduction of his statement. So he admitted that he was not aware. Even the original listed, undisputed listed location, exact location, he is not aware. Now here is a plaintiff who is not aware of his plot and filed a suit for claiming title. See my lord, the position of the plaintiff before the trial court and the appellate court. He doesn't know where he stands, and claiming the plot. Well, he doesn't know his territory. Now if he doesn't know his own territory, how he claims the land of others? How he can say that other people are taking his land? That is the position. Now I would escape with regard to, my lord, yes, 87, my lord. Similarly, before the court, respondent defendant also relied on listed such, and the same was marked as paper mark A. However, the defendant number 1, Sri Ashon Thank you, in his evidence deposed that the duplicate copy of the list deed dated such and original register dated such is in the possession of the plaintiff. Now, I would skip this 88 and 89. This will be relevant for second issue. I'll come later. Now, 90, we will start from 90.
Yes.
Further, on perusal of the list deed such relied on by both the party that was executed between such and General Secretary Sports Section Shillong Club from the said list deed such, it is clear that the appellant plaintiff Shillong Club is not the lessee of list deed dated such. In fact, that would be list deed of original list deed, 1914, though it is mentioned in that way. There is no evidence on record adduced by the appellant plaintiff Shillong Club as to how the said landed property mentioned in the list deed such was transferred from the General Secretary Sports Shillong Club to appellant plaintiff Shillong Club. My Lord, this, in fact, this should be, my Lord, the list deed I have mentioned. It should be 1914. Anyway, my Lord, number 91, the list, the deed.
So instead of just 23.
My Lord, I would stand corrected. I'm sorry, my Lord, it should be remain, my Lord. It is correctly mentioned. Correctly mentioned. Because the list it was in the name of executed by General Secretary. So the appellate court was saying that you're not adducing any evidence how you obtain the ownership of the land under the list deed from the hand of General Secretary to Shillong Club. That was the observation of the appellate court. Now, 91, my Lord, the list deed such relied by both the parties are not a primary evidence as defined under section 64 of Evidence Act. It is seen that during cross-examination, Mr. Parambar Singh deposed that he was not aware of location of original document dated 20 March 2023. This is listed and he did not produce before the court. It is, however, in their possession. From the evidence of Mr. Parambar Singh, it is clear that the list deed was in possession of the appellant plaintiff. However, no reason was assigned as to who has prevented the appellant plaintiff from producing the original list deed dated such and such before the court as prescribed under section 65 Evidence Act, where secondary evidence relating to documents may be given. Hence, adverse inference is to be drawn against the appellant plaintiff for non-compliance with the provisions of law. In view of these discussions, reasons stated above, this court is of the opinion that appellant plaintiff has failed to establish their case that they are the lawful lessee in respect of the suit property and holds the suit property under the valid perpetual lease. The declaration, the refusal of rights or status of the appellant plaintiff as prayed for in this pleading is a discretionary power of the court, and the same has to be granted according to sound principle of law. A degree of declaration is not a matter of right, considering the peculiar facts of the case prayer of appellant plaintiff is hereby dismissed. Now here the appellate court said that the original list deed was not produced before the trial court. So according to the appellate court, that the plaintiff failed to prove the validity of the list deed, though I did not dispute. And the law is very clear: when the defendant is not in dispute, it is secondary evidence also admissible. Now, according to the first appellate court, this is the appreciation of the evidence by the first appellate court. Now, my Lord, the jurisdiction of the second appellate court, as your Lordship is very much aware, is a limited one, as to whether there is a substantial question of law. With regard to, my Lord, the value of the evidence, substantial question of law is not prepared. It cannot be required to be examined. The question of fact, even question of fact is there, disputed fact is there, substantial question of law doesn't arise. Now, in view of this position, on the suggestion of the plaintiff, Lordship has prepared two substantial question of law, and Lordship could not examine the value of the evidence here, whether the evidence is rightly appreciated by the appellate court or not. Number two, whether the facts is properly appreciated by the appellate court or not, or the trial court or not, Lordship would not examine. Whether, my Lord, Lordship would examine, what the Lordship would examine is that any substantial question of law is arising from this memo of appeal, where lordship in the forensic examination is called for. In view of these two issues framed, number one is that whether relief is granted to the respondent by the trial court and the appellate court. And I have shown, my lord, the judgment and decree passed by the first appellate court, no relief granted. And here in the second appellate court order, appeal was dismissed. No relief granted to the petitioner, to the defendant here. No relief. With regard to the original list, it is still with them. The land is still with them. No relief granted. So dismissal of the suit doesn't mean that it affects to granting relief to the defendant. That is not. Well, so no relief was ever granted. And therefore, the first question of law framed by this honorable court on the situation of the other side is that relief was granted to the appellant or not. My humble and respectful submission is that no relief has ever been granted. Therefore, no question of substantial configuration of law arises. But, so the lordship of first substantial question of law, lordship prepare, order dated 12 October 2023. My lord, lordship, can you see the order sheet? I'm addressing the first question of question framed by this honorable court. Then I will go to second question, my lord.
1210.
1210, my lord.
Yes.
My lord, para 7 is.
Yes.
Well, the issues of law suggested by the appellant appears to be relevant for consideration in due course, and accordingly, at this point of time, the said suggested substantive question of law are found suitable, which are formulated herein under. So, lordship passed this order, knowing very well this is suggested by the appellant, subject to lordship further consideration, subject to be heard to the respondent. Now we are advancing, my lord, addressing this issue, and I humbly submit that the first issue, whether first appellate court can grant relief to the respondent in the appeal in the absence of counterclaim cross appeal or not. Now it says a counterclaim cross appeal. Original court never grant relief to me. I went inside the trial court empty-handed. I walk away empty-handed. I didn't receive anything. First appellate court also, I enter empty-handed as a defendant. I walk away as empty-handed. No relief was ever granted. Therefore, the first issue frame here, in fact, it is not, my lord, it is not correct. It is not correct. And with regard to that, the lordship is very clear that the section 30 of the CPC also permits the defendant to argue that after the issues are framed by this honorable court, first appellate, second appellate court, defendant has a right to argue that there is no such substantive question of law involved. Therefore, my humble submission is that the first substantive question of law framed on the suggestion of the other party at that point of time is in fact not a substantive question of law, because there is no material to show that relief was given to me. If relief was given to me, then lordship would rightly frame that relief given to him amounts to substantive question of law, because the lordship would lay the foundation.
Mr. Sarvisu, let me understand properly. I admit I'm not so well versed with this jurisdiction. Now, a suggested question of law to be framed was suggested by the parties.
Yes.
Let's put it here, the appellant. Yes. This court has considered that suggested question of law and has framed the same.
Yes.
Of course, like you said,
yes.
Now the respondent is given the chance to counter.
Yes, to counter.
Or to, to disprove.
Yes.
Such framing of the issue.
Right.
But in the meantime, what happened is, as far as this matter is concerned, the hearing on merits has proceeded.
Well,
at this point of time, at this point in time, if you say that this first issue is not substantial or cannot be maintained,
yes,
it goes. Whether at this point of time you can also make a counter, suggestion.
Well,
certain, in place of this, maybe this question of law has to be answered.
Yes.
Thereafter, the whole process started again.
My lord, the admission, my lord, the lordship would formulate the substantial question of law. Thereafter, the second appeal would be admitted. Without formulation of the substantial question of law, lordship would not admit the second appeal. So, framing up these issues was for the purpose of admission. After hearing both the parties, there is a semblance of questions are right, substantial question of law. Therefore, lordship frame it and admit for final hearing. Now, framing that one, my lord, substantial question of law, do not preclude the defendant here, the respondent here, to submit that the substantial question of law frame later at the time of admission, my lord, is not at all a substantial question of law, because I have to argue on merits.
That is accepted.
So therefore, this lordship has framed that issue. Now, when lordship entering on the merits of the case, lordship would go down to the deep, and we are pointing out that no relief was granted. If any relief was granted, my lord, that the question would be relevant.
Understood.
If no relief is granted, the question of law, substantial question of law,
will be answered accordingly.
Of course, answer accordingly. So my humble submission with regard to first question is that since no relief was ever granted by both the trial court and the appellate court, the first question of law framed by my lord, lordship may answer accordingly. My humble submission is that lordship would not need to call for interference of the first appellate court order.
In your view, it's not maintainable.
Yes. In short, not maintainable. Second one, lordship has framed the same order. Lordship kindly see whether the provisions of the Transfer of Property Act 1882 have no application over the tribal areas of state of Meghalaya in view of the operation of the Assam Frontier Tracts Regulation 1880. My lord is very clear. Any substantial question of law required to be framed in the second memo of appeal is that there would be a material on record from the plain or from the WS, from the examination in chief, cross-examination. Material should be laid down. Foundation would be laid down. Lordship would never frame a question of law which has no connection with the pleadings, no connection with the facts, no connection with the disputed questions between the two rival parties. Now, admittedly, my lord, no such memo, no such ground was ever taken by the appellant here. First, appellate court has highlighted that issue. If they are found aggrieved, they would have laid the foundation in the second memo of appeal. So the lordship will frame this substantial question of law. Admittedly, lordship would see the memo of appeal filed by the plaintiff appellant here. But the second memo of appeal my lord will kindly see the grounds started from page number 13 of his second memo of appeal. Page number 13
of the paper book.
No, it is a separate in the paper book. It is not there. It is
not incorporated in the paper book.
It is not part of the paper book, but it is separately available there.
13.
My lord, page number 13, ground. But 13 grounds has been taken by my esteemed friend to attack the validity of the first appellate court judgment.
Yes.
Page number 15, my lord. 15, it is reflected that those grounds, my lord, related to Assam from the regulation track. Ground number, my lord, ground number 8, ground number 9.
8, yes.
My friend has taken that ground.
Yes.
My lord, he has taken, my lord, for that by choosing to rely heavily on the so-called Assam Frontier Tracks regulation, the learned court below has chosen to adjudicate a case that was not placed by either of the parties.
Reply or rely?
Madam.
Rely. Should be rely.
Rely should be rely. Yeah, rely. The learned court below has chosen to adjudicate a case that was not placed by either of the parties before the trial court. The said regulation also that neither referred to nor mentioned by either of the parties, either before the trial court below or before the first court of first instance, such and such. For that, in any event, the provision of regulation do not have any application to the present dispute between the parties. My lord, this is correct. My lord, no party, both of the parties did not raise this issue before the trial court. That is not the issue. And even before the first appellate court also, that is not the dispute. That is correct. That is correct. Now, this, my lord, lordship will kindly examine whether the dismissal of the second appeal was founded on this basis or not. If this is the primary basis of dismissal of the first appeal, then lordship, the framing of the second issue required for consideration. But if it is not the foundation, rather if it is ancillary, incidental, then I would place some decision that on the ground of ancillary or incidental issues, substantial question of law do not arise. That is what the Supreme Court says. Now, when we see the dismissal order, my lord, I would, my lord, invite lordship attention again to that operative portion of the dismissal order. My lord, page 174.
Yes.
My lord, 74. My lord, 93, my lord. In view of these discussions, reason as stated above, this court is of the opinion that appellant plaintiff has failed to establish their case that they are the lawful lessee in respect of the suit property and holds the suit property under the valid perpetual lease. This is the, my lord, the order. Now, the wording appellant plaintiff has failed to establish their case that they are the lawful lessee in respect of the suit property. My lord would come to the prayer portion in the plain. This is exactly the prayer of the plaintiff in the plain was rejected. Rejected. Lordship, kindly, that plain prayer is available in page number 10 of the paper book.
Yes.
Paper book. Now, number one, declaration that the plaintiff Shillong Club is a lawful lessee in respect of suit property and hold the suit property under valid perpetual lease. Now, what they are trying to do, the seeking for, is that please declare that the Shillong Club is the lawful lessee under the lease agreement, perpetual lease agreement. So the trial court refused that one, appellate court refused that one. So, no, we are not willing to declare that you are the lawful lessee of the under the lease deed. Under the lease deed. Therefore, my lord, here my humble submission is that even if the trial court or the first appellate court declare that you are the lawful lessee, admittedly, my lord, the disputed area is beyond the lease deed area, beyond 10 acres. Without their declaration, so nobody to stop them till today. But if they get that degree, they will get additional 5 acres, 6 acres, which is beyond the lease, beyond the lease. Therefore, the trial court conscious of this position between the two rival parties. Therefore, the appellate court refused to grant the relief. Therefore, my humble submission is that this referring to the Transfer of Property Act and regulation, friendly regulation, is ancillary, my lord. But that is not the dispute between the two. Well, between the two, substantial question of law would need to be prepared from the real court dispute between the two parties, my lord. So therefore, my humble submission is the reference to the TP Act and the frontier regulation. That is not the basis of the rejection. Appellate court say that you fail to produce your original documents. You fail to establish your case. My lord, if lordship, I would show those certain paragraph of that one. Para 172, learned trial, first appellate court also cited some judgment, 172.
Yes.
Started from para 82 onwards. Therefore, the second appellate court has dismissed by appreciating all the evidences on record, available on record. And therefore, my lord, this honorable court is not going into the merits of the quality of the evidence. Number one, whether there is a disputed fact or not, lordship will not enter into. Well, regarding this, may I just please few decision. 2008.
So your substantial argument is over?
My lord, I'll come to that. Yes, almost over now. Place this decision and I would, my lord. 2010, my lord. 2010, 13, page number 216. 216. May I refer to para, my lord? Para 16, 24, 27, 28, and 30. My lord, 16, 24, 27, 28, and 30. Madam, may I read, madam? Thus, it is evident from the above that the right to appeal is a creation of a statute and it cannot be created by acquiescence of the parties or by the order of the court. Jurisdiction cannot be conferred by mere acceptance, acquiescence, consent, or any other means, as it can be conferred only by legislation, and conferring a court or authority with jurisdiction is a legislative function. Thus, being a substantive statutory right, it has to be regulated in accordance with law and enforced, ensuring full compliance with the condition mentioned in the provision that creates it. Therefore, the court has no power to enlarge the scope of those grounds mentioned in the statutory provisions. I'll come to statutory provision later, my lord. Second appeal cannot be decided merely on equitable grounds, as it lies only on a substantial question of law, which is sometimes distinct from a substantial question of fact. The court cannot entertain a second appeal unless a substantial question of law is involved, as the second appeal does not lie on the ground of erroneous findings of fact. Lordship may kindly give erroneous finding of fact. Assuming, my Lord, that the first appellate court finding with regard to Transfer of Property Act, my Lord, is relevant, it is at best considered as an erroneous finding of fact, because no party is in dispute. The trial court just simply pluck from somewhere and put there. It is can consider as an erroneous finding of facts based on an appreciation of the relevant evidence. The existence of substantial question of law is a condition precedent for entertaining the second appeal. A failure to do so, the judgment cannot be maintained. The existence of, my Lord, I'll come to, is a relation of the law, my Lord. I'll come to then for 24, my Lord.
Yes.
The powers under Section 103 CPC can be exercised by the court only if the core issue involved in the case is not decided by the trial court or the appellate court, and the relevant material is available on record to educate upon the case. My Lord, even the section, my Lord, Section 103, the core issue involved in the case. Well, application of a Transfer of Property Act vis-a-vis with the Assam Transfer Fund Regulation is not at all the core issue between me and my friend. It is absolutely ancillary. It is incidental. Now, my Lord, 26, Mary. Thus, it is evident that Section 103 CPC is not an exception to the sections and such, nor is a mean to supplant it. Rather, it is to serve the same purpose. Even while pressing Section 103 of CPC in service, the High Court has to record a finding that it has to exercise such power, because it found that findings of fact recorded by the courts below stood vitiated because of perversity. More so, such a power can be exercised only in exceptional circumstances and with circumspection, where the core issue involved in the case has not been decided by the court below. Now, my Lord would kindly consider what is the core issue issue between the two parties not decided by the trial court or the first appellate court. It's the duty of the appellant to show that one, that this is a core issue not decided by the trial court, neither by the first appellate court. The Lordship will look into. According to me, with great humility, my Lord, the issue between the parties has been decided. Number one, they failed to raise the protest objection. Therefore, Section 115 of evidence was applied by the trial court, succeeded. And they are not agitating this. They are not suggesting any issues to frame a substantial question of law on relating to this. In fact, that is the core issue between the parties. Your surrounding structures are coming up for the last 10, 15 years, 20 years, and you never raise objection. And he said, I'm not aware of that one. And trial court ignored that one. Disbelieve it. And he's not, appellant is not suggesting a substantial question of law regarding Section 115 of Evidence Act. That is the core issue. TP Act application is not at all. Now, if we travel further by 28, page 28, para 28, 27, sorry, 27. There is no prohibition on entertaining a second appeal even on a question of fact, provided the court is satisfied that the findings of fact recorded by the courts below stood vitiated by non-consideration of the relevant evidence or by showing an erroneous approach to the matter. That is, the finding of fact are not found to be perverse. But the High Court cannot interfere with the concurrent findings of fact in a routine and casual manner by substituting its subjective satisfaction in place of that of the lower courts. That if a finding of fact is arrived at by ignoring or excluding relevant material or by taking into consideration irrelevant material, or if the findings so outrageously defies logic as to suffer from the vice of irrationality, incurring the blame of the being perverse, then the finding is rendered infirm in the eye of law. If the findings of the court are based on no evidence or evidence which is thoroughly unreliable or evidence that suffer from the vice of procedural irregularity, or the findings are such that no reasonable person would have arrived in those findings, then the findings may be said to be perverse. Further, if the findings are either ipse dixit of the court or based on conjecture and surmises, The judgment suffers from the additional infirmity of non-application of mind and thus stands vitiated. In view of the above, the law on the issue can be summarized to the fact that second appeal lies only on a substantial question of law, and it is necessary to formulate a substantial question of law before the second appeal is decided. The issue of perversity itself is a substantial question of law, and therefore sections and such can be held to be supplementary to section and such, and does not supplant it altogether. Reading it otherwise would render the provision of section 100 redundant. It is only an issue that involves a substantial question of law that can be adjudicated upon by the High Court itself instead of remanding the case to the court below, provided there is sufficient evidence on record to adjudicate upon the said issue, and the condition mentioned therein stand fulfilled. Thus, the object of section is to avoid remand and adjudicate the issue of if findings of the fact recorded by the courts below are found to be perverse. The court is under an obligation to give notice to all the parties concerned for adjudication of the issues and decide the same, and giving them full opportunity of hearing, my lord. Even assuming, my lord, that regarding the discussion on the DP Act application and the frontal regulation, my lord, rendering to this lease agreement invalid, my lord, is a substantial question of law. Here, my lord, lordship would, instead of remanding the matter, would decide. That's what the Apex Court says. Now, the first appellate court say that since this DP Act is not applicable because of the Assam frontal regulation, therefore your listed is bad. Your listed is bad. That's what the other try to project. Even assuming that finding is wrong, appellate court finding is wrong. Even lordship declare, even if he declares that listed is right, still area of the land under the lease remain the same.
So according to you, it would be immaterial.
Immaterial. It is immaterial. Immaterial. That is my lord, my submission. It is immaterial, my lord. Therefore, it is not, my lord, the issue between the parties. Between the parties, it is immaterial. And the trial court, the appellate court did not dismiss the second appeal, not only on this ground. No. This is an incidental findings. The remaining findings are there. Others are there. Because lordship, I did not read all the entire evidence. The first appellate court has gone into evidence, entire evidence. My lord, the first appellate court is the final court of fact, final court of facts, my lord. So he has entered into, appreciated the evidence and rendered the judgment. Now, my lord, the one judgment that I would place.
How long will it take?
My lord, 5-10 minutes will conclude.
We have to stop here, I think. What do we do?
Only 10 minutes, my lord. Next, I can conclude also. 10-15 minutes.
We may not have time.
Yes. The next, if lordship fix another short date. Next.
Shall we continue on 22nd?
22nd, my lord. 22nd is Monday.
Tuesday.
Tuesday.
21st is
for me, no problem. Subject, my friend.
It's fine. 22nd.
Heard Mr. Serviceable and Civil Counsel for the respondent. Hearing is yet to be concluded and will continue on the next date fix. As agreed to by the parties, this is matter on 22nd.
22nd.
For further hearing.
Second call, item number 12.
Lawn chief.
This is a criminal appeal, perhaps there's some paucity of time.
We'll have it up to 2 weeks, huh?
Lordship may have it on 22nd because some from pressure from the client is in jail for rape.
What is the length of
7 years, Lordship.
And how
now?
Yeah?
2 years is elapsed.
2 years. Not half.
Not half yet. Not half.
If it is half, he would have been entitled to bail.
Lordship. Because it's not a POXO case under 376 only.
whatever the case may be, anybody who has completed half the sentence is eligible to be granted bail, pending the the appearing of the appeal, whatever. So, permitted by Mr. Estep, Counsel for the Appellant, this is matter on 22nd.
22nd, obliged.